Hello and welcome to the webinar presented in collaboration with the Connecticut, Delaware, Maryland, Massachusetts, Rhode Island, New York, Pennsylvania, and Virginia MGMA. We're sponsored today by Milmic. My name is Erin Bogus-Kimes and I will be your host. Today's presentation is led by Greg Riley and Ashley McAllister. Mr. Riley is an experienced litigator and counselor with over 25 years of experience practicing employment and labor law. As partner and head of MCB's Employment and Labor Practice Group, Mr. Riley represents employers ranging from small businesses to Fortune 500 companies in a variety of industries, including healthcare, hospitality, retail, and staffing. Mr. Riley has extensive experience in all aspects of employment and labor law, including wage and hour laws, wrongful termination, non-compete and non-solicitation litigation, class and collective action lawsuits, and litigation involving discrimination and workplace harassment, among other employment issues. Mr. Riley represents employers in federal and state courts as well as before administrative agencies such as the Equal Employment Opportunity Commission. Mr. Riley earned his BS in Industrial and Labor Relations from Cornell University in 1985 and his JD from Harvard Law School in 1988. Our second speaker is Ashley McAllister. Ms. McAllister is a partner at Martin Clearwater & Bell LLP. She is a counselor and litigator with the firm's Employment and Labor Practice Group. She represents clients on employment-related issues ranging from discrimination and harassment to violations of all state and federal wage and hour laws in a wide variety of industries, including healthcare, hospitality, staffing, accounting, and retail. Ms. McAllister successfully represents clients before the Equal Employment Opportunity Commission and the New York State and New York City anti-discrimination agencies. She provides vigorous defense in federal and state courts in employment actions and manages complex and often contentious discovery. Ms. McAllister received her BA with honors from Rutgers College in 1999 and her JD from the University of Miami School of Law with International Moot Court honors in 2008. She's admitted to practice in New York and the United States District Court for the Southern and Eastern Districts of New York. She is a member of the New York State Bar Association and the American Bar Association. Before we begin today, I'd like to review a few housekeeping items and let you know how to participate. The viewer window is on the right, and it allows you to see everything the presenters share on their screen. The control panel is on the left. That is how you can participate in the webinar. The audio panel provides audio information. By default, you have joined the webinar using microphone and speakers. If you prefer, you can join the audio using your telephone by selecting Use Telephone under the audio drop-down box. The dial-in information will be displayed, including the audio pin. During the presentation, you can send questions through the chat box found on the left side of your screen. Simply type in your question and click Send. At the end of the presentation, we will have a question and answer session to respond to as many questions as possible. As a reminder, we are recording today's webinar. You can view the recording on participating MGMA websites. Please welcome Greg and Ashley.
Okay. Thank you very much. This is Greg Riley, and I'm here today with Ashley McAllister, and it's our pleasure and privilege to talk about workplace harassment in the time of age, in the age of Me Too and Time's Up. Excuse me. Anyway, a lot going on here, no doubt. Even the unconscious person could not help but feel the waves of news reports and media attention to workplace harassment issues. It's in the news all over the place. A lot of big and heavy lifters, media moguls and Hollywood stars and folks that have high profiles have been getting in trouble with workplace harassment. And there's a short list of some of the names: Bill O'Reilly, Louis C.K., Ben Affleck, the list goes on. And it really has caused a real increased focus on issues related to sexual harassment and sex discrimination that has caused not only interest in the media, but also interest in state legislatures and local legislatures, and even some attention on the federal level, which has affected the laws. And we'll get into how the laws have been changed in some ways, and how it's actually playing out in the real world. But there's no doubt that this workplace harassment has gained new attention in the last year that it hadn't had before. Today's program, here's what we're going to cover briefly. Recent changes in the law on the federal level. We're also going to talk about New York State. I know there's folks here from listening from a bunch of different states. So we're going to talk about New York, not so much because we got New York listeners, although we do have a lot of New York listeners. But we're going to talk about New York because New York has New York just passed in April of this year, one of the most comprehensive anti-sex discrimination laws in the country. And it has basically a lot of provisions that are modeled or in other states, so it's kind of a good template to talk about. We'll talk about...
Hey, Greg.
Yes?
Sorry, I didn't mean to interrupt you. Can you just speak up a little bit louder? Some people are just having trouble just hearing you, so if you could just talk a little bit louder, and I think we'll be great.
Okay, thank you. I understand there's a little trouble hearing me, so I'll speak a little louder. Anyway, what I was going to say is that as an overview, we're going to cover the changes in the law, federal, state, and local changes. Also, we're going to discuss how these changes directly affect healthcare employers, and then some proactive approaches for how healthcare employers can adjust to this new reality of increased focus and frankly, you'll see increased claims for sexual harassment. So as far as recent changes, the federal laws haven't really changed all that much. We're going to walk through that. But there's been a lot more activity on the state and local level.
Right, so what you're looking at right now is the EEOC published numbers for the fiscal year of 2017. The final numbers have not been published for 2018, but we wanted to kind of give a look at how the claims are coming in and what ones are more prevalent than others. Obviously, you see here that sex claims in 2017 were somewhere in the middle, and with retaliation being the overwhelming prevalence of claims. What we see a lot is retaliation is oftentimes an add-on claim. So if it's a race discrimination claim, retaliation would be added on to that. And I think that's probably some of the reason why retaliation, the numbers are higher than one would normally expect.
Right, you have an underlying claim for any kind of protected category like race, disability, age, and almost invariably there's a tag-along retaliation claim. So that number it's always been, frankly, the highest number. But I think this chart really shows that at the EEOC, the charges that had been were filed in 2017, it was a moderate number of sex claims compared to the other kinds of discrimination claims.
Right, and so we've got some indication of where the numbers will fall for 2018, although they have not been finalized as of yet. But the projection for this is that there's going to be a massive rise in the number of sex harassment charges, probably close to an increase of about 14%. What I think is also very interesting is that at least preliminary numbers are showing that the number of lawsuits that the EEOC has filed in 2018 is considerably larger in terms of the sex harassment claims. There were 66 lawsuits filed in 2018. 41 of them were sex harassment claims, and that represents almost a 50% jump in the numbers from 2017. So they are also reporting preliminarily that the number of sex harassment claims has jumped about 24% in 2018. And interestingly, there has been an increase in reasonable cause findings, which I think is an interesting response. I mean, we kind of expected to see the number of claims rise, but you wouldn't necessarily expect to see the number of reasonable cause findings to rise. But they're reporting that that could spike up to 20% higher than last year as well.
So, interesting. Federal anti-discrimination, anti-harassment law. Here, we've had really no significant change on the federal level about what constitutes prohibited harassment. I mention this because you get the impression from watching the news and like people getting taken out of the workplace like Matt Lauer or Bill O'Reilly, and you think, oh, well, maybe the law got tougher. Well, not on the federal level. The law really hasn't changed. The standards for determining whether something constitutes sexual harassment remains the same, which is, there's basically the same two types of sexual harassment. One's quid pro quo, which is the caveman type sexual harassment. Sleep with me and you'll get a raise, or don't sleep with me and you're going to, get fired, or your working conditions will be harmed. So that quid pro quo, that's still impermissible. The definition hasn't changed. And then the other kind, of course, is hostile environment sexual harassment, which, again, the standard hasn't changed. That's when the perpetrator's actions are so severe or pervasive as to affect the terms and conditions of the victim's employment. It hasn't changed. So you would think you'd see all this change where at least in the media, where you see more, it seemingly actually now that we have the EOC statistics, not only seemingly but in reality, there's more of these claims. But the underlying law on the federal level has not changed. They're still using the same standards for quid pro quo and hostile environment harassment. Having said that, there were some changes at the end of, and this doesn't really change the definitions of sexual harassment, but it changes how sexual harassment matters have to be handled. In 2017, at the end of the year, in the tax bill that was passed, there was something called the 2017 Federal Tax Cuts and Jobs Act, and it was like basically a two-sentence provision there that said that if you have a settlement of a sexual harassment claim, a company can't deduct that from their taxes as a business expense if the settlement is subject to a non-disclosure agreement. So that was like a nod to the fact that near the end of 2017 there was increasing sexual harassment claims, and the government, federal government at least at that time when they passed this, was thinking, oh gee, one of the problems that they're seeing, for instance with the Harvey Weinstein, or you can call it the Weinstein effect, was that some of these moguls of the media and industry were, they'd get in trouble with sexual harassment claims, and they would, as they came up, they would settle them with the victim and have a non-disclosure agreement. So they pay off the victim, get a non-disclosure agreement in exchange for a release and quiet confidentiality, and then nobody else would ever know about the alleged sexual harassment, and the perpetrator didn't have to correct their conduct, and there'd be like literally a serial harasser, as it seems that Mr. Weinstein may be, or at least he's been accused of being. They would be getting away with it, and then it would be no correction. Well, the federal government here is basically saying, if you're going to take that approach, we're not going to permit you to, and you're going to take that approach, and we're going to require confidentiality resolving these claims, then you can't take that tax deduction. So it's a little change in the law, but I'm not sure it's going to matter that much at the end of the day. But employers have to think about that and when they're settling these claims. The other thing that's going on at the federal level is the EEOC has proposed enforcement guidance on unlawful harassment, and it's been out there for more than a year now. It's 75 pages long, and it talks all about sexual harassment, and it's supposed to really make a game changer as far as helping employers. I respectfully, 75 pages is hard to digest, and it hasn't been finalized yet, and we'll see what it says. But that is out there. Of course, if the EEOC says, they offer guidance and they suggest employers should act one way or another, then of course employers got to take that seriously. So once that does eventually get published, most employers are probably going to be guided by that, and hopefully compliance won't be an issue for most employers. But we'll see. But that's it. I mean, it's some proposed guidance and a small change to the tax code at the moment. That's all there's going on at the federal level.
Okay, so as Greg previously mentioned, in April of this year, Governor Cuomo in New York State signed into law an extremely comprehensive sex harassment law. And we're going to delve into some of the aspects of this law, again, as Greg had touched upon, because it is so comprehensive, with recognition that some of you are in different states, but obviously this is we're on the forefront, basically, of a lot of these laws, and it's probable that there are going to be other states following suit, at least in part, for some of the provisions this law makes. So some of the provisions of the New York law were made effective immediately. Some were kind of staggered in terms of a time frame for employers to comply. The first portion of the law that I want to highlight is that it creates its own definition of sex harassment.
Yeah, which is, by the way, a little weird in a way, because you would think, New York, why doesn't it have a definition of sexual harassment? It never did. It just, there was kind of a built-up understanding of what constitutes sexual harassment. They borrowed from the Title VII and the EOC,
yeah.
But New York didn't have a real definition, so they finally legislated one, and we have it on the screen now.
Yeah, and it's basically what you would expect it to state, and that went into effect at the signing of the law. One thing I will point out in terms of the definition that I think is important for everybody to remember is that we're talking about unwelcome behavior, and we'll get into a little bit more about sometimes things are consensual, sometimes they're not, but what constitutes sex harassment has to be unwelcome. So one other important aspect of the New York law is that it expanded the types of people that are covered. So now non-employees are also provided protection. This is incredibly important, especially when you think about your type of workspace and the types of people that you interact with during your workday.
Like in a hospital.
Right, or in any type of medical facility. You've got other than your actual staff and employees, you're going to have vendors coming in, you're going to have pharmaceutical reps, you're going to have people that are outside the actual employee-employer relationship, but as it stands now in New York State, these people are protected. So we're talking about contractors, subcontractors, vendors, consultants, anybody who's in your office space or in your facility providing services can be covered by the current New York law.
Okay. New York also required now that we have a sexual harassment policy in place. as a legal matter. We've, of course, advised employers for many, many years that they should have a policy against sexual harassment, and most employers, or certainly most sophisticated employers, have it. Well, now New York requires it as a matter of law. That's not a bad thing, of course. What is a little unusual here is that New York actually legislated what should be in the policy. I mean, they're getting pretty much in the weeds here, what has to be in the policy. And while this may not be that instructive for some other states, it's helpful in New York. And I guess the instruction for the other states is if you put in everything that's in the New York requirements, and you're in Delaware or Connecticut or Massachusetts, you're likely in compliance with not only those laws, but you're like ahead of the game. So what am I talking about? Why do I think this is all in the weeds? Well, they actually make you have a complaint form. So the employee comes in and they have a form they can fill out. You know, a lot of employers, take complaints and they direct you to their HR person if somebody has a complaint. But I have yet to see a law that actually requires you to have a complaint form. And then New York actually gave you a model for what it should look like. So that's one example. The other thing that is, I think, really something I don't actually like because I represent employers, is that it requires the employers to put in their policy, which is in their handbooks, the phone numbers and contact information for the New York State Division of Human Rights and for the EEOC and for the New York City Commission Against Discrimination, New York City Human Rights Commission. So, and it basically it permits the employees to, go to those places and of course they always had the right to go to those places, but now we're kind of like giving them a roadmap how to go to those places to get redress for sexual harassment claims. And the reason I don't like it is, employees have the rights, of course, and they should use them if they feel they need them. But I always viewed the anti-harassment policy and handbooks as the employer's first opportunity to resolve these disputes in-house. And then if the employee had a problem and they couldn't get a satisfactory resolution in-house, then they could go to one of these agencies, and that was certainly their right. This may encourage employees to go to the outside first rather than try to resolve things in-house. But that's what the law is, so that's what we have to live with here in New York. But but some other states have that, and we'll get into that. That they require you to put in that policy itself how to get to the local or state agency for redress. So one of the other things that New York has, and we'll talk about this too, a few other states have it, is that they made it a requirement of the law. Employers in New York have to provide sexual harassment training. We used to recommend that employers provide sexual harassment training. We used to say that's a great thing to do because it could be a helpful defense. If you ever had to go to a trial, you could say, hey, I trained that manager not to do this, and yet there he goes. He did it anyway. So we always encourage employers to do this, but now we're not just encouraging them. We're saying, no, you must do it because that's the law. And they make that for every employer in New York, regardless of size. In New York State, you're covered under the state anti-discrimination law if you have 4 or more employees. Now, even the smallest employer, you have 1 employee, you got to give that sexual harassment training. And it's got to be provided once a year to all employees. Once a year. The deadline in New York is October 19th, It's October 2019, so they got a year to do it. But it's for all employees every year. So there's going to be probably a small market in providing sexual harassment training, maybe a big market for outside vendors to provide sexual harassment training. And a lot of employers are going to probably try to do this in-house, which is either way is permissible. And then all new hires have to be given sexual harassment training under the New York law. And for new hires, that's the law doesn't specify exactly the time frame, but it says as soon as possible, which I would recommend is within 30 days. But that's a new thing. Some other states require sexual harassment prevention training, but New York is probably on the liberal edge of it. So that's a change in the law, and that's where I can see if your state hasn't gone there already, it's quite possible that it will go there soon. In New York, some of the things that they require, and this is require, not guidelines. These are part of the law. They're telling the employers exactly what should be in the training when the people do the training. And I'm not going to walk through all of these that are on the slide here, but it has to be interactive. You can't just show them a video and they fall asleep and the hour's up and that's it, and you check the box and say they got the training. No, it's got to be interactive. There's got to be either a Q&A or they have to answer a quiz or something like that, so that there's some way to make sure that people are actually getting trained, and they can ask questions if they have any questions. The other thing is, again, they're requiring during the training that you provide the potential sources for administrative redress. Again, the EOC's contact information, the New York State Division of Human Rights contact information, all that kind of stuff. They're actually saying, you do this, you have to do this to provide adequate training. The other thing I guess I would add here is that New York they did a little more detailed than what happened with the federal government when they did the two-sentence change to the tax code. In New York, they said, you know what, we're going to put some restrictions on what you can do for confidentiality settlement agreements. The concern at the federal level and with New York now is the same one I mentioned before. If you settle all of these with confidentiality, the problem may never get resolved, and the employer could just continue to engage in sexual harassment and just pay the victims off as they go along. So it prohibits employers, this new law prohibits employers from including non-disclosure provisions in their settlement agreements unless the complainant requests confidentiality. They have to request it and agree to it. But even if they agree to it, the complainant has they must be provided at least 21 days to consider whether they want to enter this non-disclosure. And then even after they sign the agreement, 7 days to revoke their acceptance of the confidentiality or non-disclosure provision, which this, you may all hear or remember, this 21 and 7 thing that's basically the same thing that from the Older Workers Benefit Protection Act, the federal law that puts restrictions on settling claims of older people. Although that, it's extra protections. And that's now in effect in New York. But, kind of stepping back from it a little bit, I think the message or the observation, I guess I have, is that sexual harassment, at least at this time in the United States, has been elevated higher than many other kinds of discrimination. So let's say it's race discrimination or disability discrimination or national origin discrimination. Well, there's no requirements under other state laws in New York as well that you provide special training. Think about that. There's no requirement that you have a legal requirement that you have a policy against discrimination for disability or national origin in New York, and there's certainly no requirements for how you release those claims and how you whether they can be settled with confidentiality. But in New York, they've made these special protections for victims of sexual harassment. They've given them extra rights more than other protected categories. And one could question whether that's right or wrong or the appropriate way to proceed as a policy matter, but that's the way it is, and it's kind of a curious difference, I suppose. And I think it definitely reflects the power of this Me Too movement and the increased focus on sexual harassment. The other thing that they did in New York, again, elevating sexual harassment claims, is they said that employers can't require mandatory arbitration for sexual harassment claims. So a lot of employers have policies, and not a lot, a good third of New York employers have mandatory arbitration clauses. So if workplace claims come up, instead of going to court, the employees are required to try to arbitrate it with their employer. And those agreements are enforceable in New York, except New York State changed it up for sexual harassment and said you can't do mandatory arbitration for sexual harassment claims. Yeah, they have a special carve-out. In the slide it says, is it enforceable, question mark? Well, excuse me. It may not be enforceable for New York to set up such a carve-out for prohibiting arbitration of sexual harassment claims. And the reason is the Federal Arbitration Act may preempt the New York State law. We'll have to see what happens here in New York if it gets challenged.
Okay. So understanding, again, that not everybody listening today is sitting in New York or an employer in New York, I wanted to talk a little bit about some of the other state laws and some of the things that are common to them. In terms of training requirements, there's actually very few that have mandatory training requirements. Obviously, New York, Connecticut is a state that has had training requirements in place for quite some time. Pennsylvania and Rhode Island, interestingly enough, they do require it, but only for state employees, not for all employers. And I'll also note that Delaware, as of the year 2020, is going to mandate training for all employees. Agency contact information. So even in the most lax sex harassment or discrimination laws, all of them encourage and state that an employee, whether part of your written policy or done as a separate exchange, all employees should be given the information of how to make a complaint to whatever their state Commission of Human Relations or the Division of Human Rights, as it is in New York. All of that information has to be exchanged with all employees. So that is the case in Massachusetts, Rhode Island, Connecticut, Pennsylvania, Delaware, Maryland, and Virginia.
I must be a dinosaur. I'm used to seeing that, you have to have a mandatory poster up, but now they're saying it's got to be part of your policy.
Yeah, it has to be specifically communicated with the employees. One of the other things that we see that differs from state to state is the number of employees covered. So as Greg mentioned, the discrimination law in New York is 4 or more, but the sex harassment portion of that and the training requirements and everything else apply to all employers. So we see Pennsylvania, for instance, the sex harassment law applies to employers who have 4 or more employees. That's also the same in Rhode Island and Delaware, 4 or more. Massachusetts has a higher standard. It's 6 or more employees. Virginia has a little bit of a stranger law in that it covers employers who have 5 or more employees, but less than 15. And I don't know exactly the rationale behind it. My guess is that because the federal law covers employers with 15 or more employees, the Virginia state law then covers smaller entities, but not entities smaller than 5 employees. Lastly, Maryland mirrors the federal law, which states 15 or more employees. As Greg had mentioned before, or actually I think I mentioned it before, the scope of liability has changed a bit to cover non-employees in terms of the New York state law, and there's other states that have adopted some or all of that. For instance, Massachusetts also covers non-employees, but Connecticut and Maryland have done something slightly in that vein in that their laws cover unpaid interns. Not necessarily all non-employees, but unpaid interns are covered. Also interesting about Maryland is that there is a disclosure law that has been enacted and goes into effect in the year 2020, in which employers are going to have to report all settlements and details about the settlements of any sex harassment claims. So that's an interesting move somewhat in the same vein as what we're doing in New York. Also to note, all of the states that we've been talking about, Massachusetts, Rhode Island, Connecticut, Pennsylvania, Delaware, Maryland, and Virginia, all have extended their sex harassment and discrimination laws to cover gender identity as well as sexual orientation. So those are protected classes under those state laws. I'll also note that, obviously we're going through the New York law, and as we said, it's very comprehensive. It's very detailed. And I think when, as employers, when you're looking at your policies, whether or not you're going to train your employees, one of the things, and as Greg said before, complying with what the New York law is now is not a bad idea. And certainly if a claim gets brought to the EEOC or one of your state division of human rights agencies, these are the types of things that those agencies do look at, especially if it's not required. If you're providing training, those types of things are taken into account when they are analyzing liability on the part of the employer.
I would just say a few notes on that and how it affects the healthcare industry. When the training is provided, some employers are going to probably just do something out of the can they may get from a HR company or their accountant or whatever. I would suggest that it is better, and it's not a legal requirement, but I think it's better when training is provided that's relevant to your workplace. So there's peculiar issues that arise in the healthcare setting. I mean, Ashlyn can speak about that, but that you'd want to account for in the training.
Yeah. Yeah, I mean, I think the healthcare industry is in a unique position where they are serving clients and patients on a daily basis, but you also then have your workplace environment as well. So the level of interaction between your employees, either with other coworkers, but also with patients on a daily basis is exponentially higher than a lot of other industries. And talking about what is appropriate in terms of dealing with patients. I know the AMA has rules against relationships and things like that between a doctor and a patient, but I think in general it's interesting to think about how these things arise, right? We're talking about comments. We're also talking about when you're in close proximity to somebody else. Obviously through, in the medical profession, you have to be physically touching at certain points patients, but thinking about how those types of things play out in terms of the healthcare industry is unique to yours.
Right. The training should be applicable to healthcare. I think kind of common sense, but a hospital had beds. Well, beds are usually where people have sex. And there it is. People working late at night in a place that has lots of beds.
Mm-hmm.
You know, a lot of workplace environments, most workplace environments don't have beds in them. So you think about that and how that could affect how you provide the training.
Another instance I'll bring up too that's common to the healthcare industry is the interaction with pharmaceutical salespeople. There are oftentimes dinners set up by any given company or rep, and people from the office are invited. There's alcohol there. So you're not physically in the office or in the medical facility setting, but you're still with coworkers. And when anytime there's alcohol involved with coworkers, it can lead to problems. So these are just some examples that are unique to the healthcare industry.
Yeah, you know, the change in the focus, increased focus on sexual harassment, has made it clear too that, and most employers should know this already, but I think it bears repeating, that it's not just employee upon employee interactions that can give rise to these claims. So a patient could sexually harass his or her nurse. A vendor could harass the receptionist. You know, the FedEx guy could be bothering the receptionist at the emergency room. Whatever it is, I mean, and those even though they're not your employees that are causing the harassment, you could be held liable if you fail to correct it. You know, I've got a library client now. It's a different workplace, but they have problems sometimes with their patrons, the people that come in to use the facility and read books or watch videos or, you know, go on the computer. That's where the problems come up there. And in a hospital, of course, as Aisling said before, there's so many different people from all different places, like the patients' families, the vendors, doctors who are on privileges. It's just an extraordinary place of human interaction. Of course, when you have human interaction, you have opportunities for sexual harassment. So how has this Me Too movement and Time's Up affected employers? I think significantly. Most employers are taking this seriously, and they're trying to, you know, both comply with the law and maybe even get ahead of it. And we're getting a lot of calls on this. And I think there's no clear solutions in some cases. I had a CEO come to me 2 weeks ago and said, you know, well, what do I do? I've built up a small fortune, worked very hard my whole life. What if I get sued for sexual harassment? I don't think I've ever done anything wrong, but I'm vulnerable to these claims. Should I not have women come into my office alone? Do I need to have a chaperone all the time? What about leaving the office? I can't go out and have drinks with them. Maybe I should only mentor young males instead of mentoring everybody. I mean, and you know, these are tough questions. On one hand, you want to, you want to protect your clients so that they don't get sued for sexual harassment. On the other hand, you don't want to impair the workplace so people can't learn and succeed, especially women. And the concern I would have with that is that women may suffer for the increased focus on sexual harassment, that they may be denied opportunities. So these are tough issues, but there are some things that are clear about how employers should respond. Proactive approaches. You have to have a handbook policy. In most cases, state law requires it. Federal law certainly encourages it. Training, again, mandated by some states, should have that. And then third, I'd say employees, both in the handbook and in the training, have to be encouraged to report the alleged harassment when it happens. This is kind of my one of the things I just find troubling in all the recent Me Too stuff that's going on and what I see in the media. People reporting things that happened 5, 10, 15 years ago. Think about the claims against Harvey Weinstein. Think of the claims that were made against Judge Kavanaugh when he was up for confirmation. I'm not taking a position on these things, but it certainly would have been easier to resolve these things at the time they arose. And frankly, I think employers want to encourage that. So I not only require my clients to, have policies that comply with the law, but I also require them to have language in their policies that says, you must have. We really highly recommend that you report these claims or things that you think might be sexual harassment at the time they occur. Why? A lot of reasons why. One, we don't tolerate sexual harassment. 2, we can't stop it if we don't know about it. 3, the sooner you report it, the sooner we can stop it. 4, if you don't report it when it happens, it becomes hard to investigate. People leave the workplace. They resign or they're fired, or people's memories fade, or documents might go missing because the automated electronic document destruction policies. It's so much better to nip this in the bud while you can. And I think most employers don't want claims of sexual harassment, but if they do get one, they'd like to be able to handle it quickly and efficiently and provide prompt and appropriate remedial action. Why don't you speak on this, sir?
So another area that gets problematic for employers is when at one point a relationship was consensual and then one person either falls out of love or doesn't want to continue with the relationship, and how does an employer deal with that? So basically dating in the workplace. Some employers opt for policies strictly against fraternizing and dating in the workplace. But, as a practical matter, and especially in the healthcare industry, there are long hours. You are spending the majority of your life with your coworkers. And oftentimes you will see your coworkers more than you'll see your girlfriend, your boyfriend, your spouse. So we have to think about this realistically, that dating is going to happen, whether you have a policy against it or not. Another way that employers can deal with this is what's called the love contract. Basically, an employer says that if a relationship does spark up between two coworkers, you have to report the fact that you are in this relationship. And that's one way to deal with it as well. But like I said, you spend so much time with your coworkers that prohibiting this type of stuff is potentially futile. It's just better to handle it appropriately when it comes to your attention. It can also, it's kind of a hotbed to lead into sex harassment claims, and we see that quite a bit, where a relationship was consensual at one point, one person doesn't want to continue the relationship, and now the other person who wants to remain in the relationship is continuously approaching the person, sending them inappropriate texts, emails, whatever it may be.
There's some things that can be done to perhaps mitigate the potential for a sex harassment claim. One of the things that sometimes arises is we get asked to make what they call love contracts, but basically if there is going to be a consensual relationship, we say as an initial matter that two people shouldn't be in the same department and one shouldn't report to the other. And then the other thing is we, in some cases where appropriate, we've come up with agreements that say, the two people who are engaged in this consensual relationship agree it's consensual, and that they'll advise the employer when they break up, if they ever should break up. But we'd like to, in some instances, have something in writing where they acknowledge the existence of the consensual relationship, so they don't have to, so there's no potential claim later of sexual harassment. Let me also add here, it's not directly related to love contracts, but the same underlying theory applies. I've observed in the last 6 to 8 months, a lot more sexual harassment claims. But what I've noticed is a lot, not all, but a lot of them are less meritorious than maybe they were in the past, or they are more questionable. Maybe there is sexual harassment, but it's on the margin, and it's not clear if it was sexual harassment, if it meets the definition. But people are seeing the media, and they're bringing these claims in. I think in good faith, for the most part. The employers that I represent, a lot of times they're saying, you know what, we're concerned about Me Too, because if we don't resolve this one and it goes to it turns into some type of litigation or claim, it might foster other claims to be made, and that's the risk employers are concerned about. So maybe that claim isn't so strong, but maybe that claim will encourage other people to make similar claims. So there's a greater desire amongst employers to resolve these things quickly. What does that have to do with love contract? Well, I would suggest that employers think about this. If your regular day-to-day HR practices are in place, it goes a long way toward reducing number of claims for sexual harassment or other kinds of discrimination. What do I mean? If you got performance problems with an employee, you gotta like write up the warnings, do the progressive discipline with written warnings. You gotta put it in writing, and you gotta create stakes in the ground to show that there's a problem, because many employees have learned over time that you can turn things around, or the best defense is a good offense by making a claim. And in this world, a sexual harassment claim is a good offense to make a defense of if somebody thinks they're at risk of losing their job because they're a poor performer. But if you've laid your stakes in the ground in advance with progressive discipline and documentation of performance and disciplinary problems, then these meritless claims or marginal claims are less likely to arise, in my opinion. So good HR practices go a long way to reducing the potential problems. It's not exciting news. It's news you've heard before. Document, 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 but we repeat it here.
So prevention of harassment really is everyone's responsibility. Greg and I always talk about culture in your workplace really being set kind of from the top down. And this is part of that. I mean, even if it's not you who is the person who is the victim of harassment, if you witness it, it is important that you encourage all of your employees to feel comfortable to come forward and report it. Because obviously if if there's a situation going on where your employee is uncomfortable, doesn't want to come to work, isn't producing at the same level that they were due to a situation, whether or not they themselves come forward, it's important that somebody says something. So, at the New York adage, if you see something, say something. It works here. It works in terms of sex harassment as well.
I think New Yorkers like to think we came up with that. I don't know if we came up with that.
I don't know. It's all over the MTA. So, but certainly it's important here. You want to foster and encourage a culture where people feel comfortable enough to report anything that they may find troubling. And I think it works overall to keep a healthy workplace and a productive one.
We listed here some things that proactive approaches and things employers should be doing or thinking about. Some of these we've talked about. Some of them may be self-evident. But I would suggest that of the things here, keeping communication open is probably the most important one.
Yeah, I really like to periodically ask employees for input and ideas. I think it's important, especially in a larger office, that you'd be surprised at the amount of information you get if you ask, as opposed to waiting for somebody to come to you. And I think kind of, setting a culture where the the people at the top are kind of keeping their finger on the pulse of what's going on a day-to-day basis with everybody is a positive thing.
Well, I'll add a caveat, not a caveat, I'll add a corollary to it. You can ask not only employees, but non-employees. And what do I mean? When somebody resigns, you can give, the exit interview. That could be a great source of things. So you ask the person, hey, anything you got a problem with when you worked here? Anything that we should know? Anything that troubled you? Anything we could do better? Questions like that. And it helps, one, because they've got no horse in the game anymore because they're leaving, or horse in the race, so that you may actually learn something you could take advantage of, and maybe if there's a problem, correct it. But two, if they don't put anything down and they sign that exit interview form and they didn't say there was a problem, well, you can pull your exit interview form out when they bring their legal claim 2 years later, and you say, well, you're claiming sexual harassment now, but you didn't say anything about that when you worked for us or even in that exit interview form. So that's like the kind of things that employers should do. It's part of keeping communication open and soliciting people to speak up.
And documenting.
And documenting.
Yeah.
Again, document.
Yeah.
Okay. I think we're almost out of time here. Questions? I don't know how this works here.
Hi, Greg. I can read the questions to you, for the good of the group, or you can take a look down in the chat box. How would you like to handle that?
Let's go out of the chat box. I think I can read it here.
Yeah. I'm not sure if Chris's question is facetious or sincere. Is New York State themselves responsible for following the law?
Yes, New York has its own, public employees are subject to the same law.
Yeah, it covers all employees, state and private and public.
Yeah. Parts of the law.
And then, go ahead.
We have another question here. It says, in New York, what parts of the new law are required to be implemented right away?
All of the portions that we've discussed here are now in effect. All of them are. So it started in April, and it was rolled out, and the last date was October 9th, which was the training. So everything is in effect.
Yeah. Here's another. This is a good question. Someone asked if the prevention training is not performed, are penalties defined in the law? And the answer is no. There's no penalties defined in the law. They make a law with no penalties. The risk, I think, even though the law doesn't specify penalties in New York, I can't speak for the other states right now, but I think that certainly the risk in New York is if you didn't put it in the appropriate training and you ever get sued,
right,
someone's going to point out and say, well, I'm a victim of sexual harassment, and it could have been prevented if you provided the training and you had the right policy, and but you didn't cross your T's and dot your I's, and now I'm a victim, and therefore I'm entitled to enhanced damages under, like, for instance, the New York City human rights law. You can get enhanced damages if you didn't take appropriate measures to prevent the harassment. So you want to do it, but there's no specific penalties in the New York law for if you don't do the prevention training. Here's another question. The question is, could this policy be a part of an employee handbook, or do you need a separate book or policy just for harassment? It should be in your, first of all, sex harassment policy should be in your handbook. Let's start there. Definitely put it in your handbook. You cannot put it enough places for my liking, but definitely have it in your handbook. And then I also like a separate one, and I tell you why. I like, because I'm a trial lawyer, Ashley's a trial lawyer too, a lot of times when you go to trial, you want to have something that's a standalone document that's signed by the employee, and it's dated by the employee, so you can throw it in front of the jury and say, look, here's the policy, and they signed it. Whereas if you have a handbook policy, it's one of many policies that get stuck in the book and may collect dust on the shelf, and it's not given the importance that it may deserve. So if you have a separate policy and it's signed and dated by the employee, I think that's super especially if you ever have to be in front of a jury. God hope you're not, but if you are, I love that.
Yeah, so just as like an internal policy, giving them out every new hire, that type of thing, so that you can keep it in the file. And then if you're in New York, you got to update the training on an annual basis. So having somebody sign something, that's actually a requirement of the law as well. Once the training is performed, you want each employee to sign something that can be put in their file to denote that they actually attended the training on an annual basis.
Here's a question. It says, how does the anti-harassment law apply to a situation where a patient regularly sexually harasses one or more staff in a private practice? And then there's interesting, here's another person that says, and we see that in our practice too, someone else writes. And the short answer is, it applies, absolutely. You could, as the owner or of a private practice, you are responsible for what happens to your employees. And if it's a patient who's sexually harassing your employees at that practice, the owners of the practice can be held liable, and the practice itself could be held liable. What would you do in that situation? Because you don't really, it's not like your patient is your employee. Well, what you can do is you can speak to him or her and say, don't do this. If the misconduct continues, then you gotta tell the patient, you can't be our patient anymore. You've got to get rid of that, because one, it's the law that your employee shouldn't be harassed, but two, that's just not acceptable. It's just not acceptable at all. So, and you could be held liable if it does occur. So I think that's a good question. Next question I see, what have been the average losses or defense costs for these claims? That's a tough one.
Yeah.
I can just give you some generalizations that these claims generally are resolved. I mean, unless they're horrendous, and the range of misconduct varies tremendously, from actual criminal activity like sexual assault or rape, all the way down to a
comment about somebody's nipples showing through a shirt. It can be anywhere in between. And
so the range of loss, the range of a potential verdict against an employer for sexual harassment could be it should be consistent with the level of misconduct that occurred. Having said that too, though, the risk the employers have is that even a small claim can be expensive to defend. And that's why employers do well to try to resolve these through proactive measures like providing the training, having the policies, and nipping these things in the bud.
But they can be expensive.
Yeah.
They can certainly be expensive. Actually, I'll throw one more statistic, which is somewhat relevant to the question. The EEOC, again, these are projections for 2018, but the EEOC is reporting that they recovered nearly $70 million for alleged sexual harassment victims this year, which was almost double than what it was in 2017. So there's a lot of money exchanging hands in regards to these sex harassment claims, and it can be very expensive for employers.
Yeah. Here's another question. If an employee asks for an exit interview and the employer does not provide one, and the employee had things to discuss, is the employer open to claims, possibly hostile workplace? Well, here's my answer. Employers are not legally required to do exit interviews, so you cannot be held liable for not doing them. If an employee asks for the exit interview and you don't give it to him or her, they don't have a claim based on that. You can call it an exit interview if you want. Exit interview I would put in the category of just open communications. If that employee has something they want to tell you, I think I want to hear it. Whether you call it exit interview or just tell me what happened, I'd want to hear it, but you're not required to do that. If they resign, you're not required to even talk to them after they resign. But it's a good thing to do if they have something to say, because you might learn something that could harm your practice or your hospital, and you'd want to resolve it.
Yeah, I was just going to say, or if this person does have a complaint to make, obviously you can attempt at internally resolving the issue before they leave the workplace and potentially file a claim with either an agency or a court.
Let me add something else here that perhaps many of you know, but I'll say it anyway. These things like having a policy, even before it was legally required to have a policy in a state like New York against sexual harassment, it was very much encouraged by the state of the federal law that was decided in the case law, and in particularly the cases of Farragher and Ellerth that were decided by the Supreme Court. And what they basically said is, if you have coworker upon coworker sexual harassment, the employer may have a defense and be able to mitigate liability if the employer has in place a policy that prohibits sexual harassment, and that policy provided avenues to communicate complaints, and then if the complaints are received, they're investigated and there's prompt remedial action. So these things can act as a defense. These compliance with these policies and investigations and taking prompt remedial action as appropriate act as a defense, and you want to have that in place. Having said that, why do I mention that at all here? Well, if you think about it, somebody, if they want to complain after they resigned, I'm actually happier to hear that after they resign, because if I have my policies in place and they had the opportunity to complain before they resigned, their claim is already weak. So it's almost like a freebie to get it at the end after they resign, because they're gonna, if it's a complaint that they have that they think they were sexually harassed, you can always say if there's any substance to the complaint, you can always say, hey, we had this in place and you never said boo, now you're resigning. It gives you a nice defense, assuming you have everything in place. It's good to know. And the other thing is, if they're telling you this, it's better that they tell you this now in the exit interview or the post-resignation or post-termination conversation than telling a state or federal agency about their discrimination claim. They may still do that, but who knows? Maybe you can resolve it without them going to taking it to the next level.
Right, and I think what Greg just said goes along with what I was saying earlier in terms of, yes, New York is more comprehensive, but when you're looking at doing your own policies and whether or not to train, those types of things, you can never go wrong doing more than the state that you're currently working in requires. So if you followed New York as an example, I think you guys would be all set in terms of asserting the defense that Greg just explained.
Yeah. There's a question here. It says, should the patient policy be included in the patient code of conduct or our sexual harassment policy, or both? Well, let me, I'd say both, and let me be clear what I'm talking about. As we've discussed today, there should be a sexual harassment policy that applies to employees, and that sexual harassment policy should say that if you have a complaint about sexual harassment in the workplace, please report it. And it should explain that it doesn't have to be a coworker or a manager or supervisor who's engaging in the misconduct. It can be outside third parties, such as the vendors or the patients or the if it's a hospital, the people that have privileges, so that the employees who are subject to the policy understand that the scope of potential misconduct, or the scope of people who engage in misconduct, is broader than just people employed by your hospital or your healthcare organization. So that's on the sexual harassment policy applicable to employees. As far as patient conduct code, yeah, I mean, I think it's appropriate to say those codes are usually about how the patient should be correctly treated in the practice or the hospital. But I think you can also have, at least in a part of the patient code, but frankly probably outside that code, a separate document that says, you know, we don't tolerate sexual harassment. Our employees should be treated with respect, and you can even have posters up for that, or is something as a condition of treatment the patient agrees in writing. But those are good questions.
Yeah. Well, thank you very much, Greg and Aisling. We have your contact information here.
Yep, on the last page there on the screen.
Yes, and I want to thank everyone for joining today's webinar. The link to the recording and presentation will be distributed by each state affiliate through email. Following the webinar, you'll be sent 2 brief surveys. One will ask you to rate the webinar using a 5-star scale. Then you'll be sent a separate email and link to our online webinar survey where you can provide us with feedback about today's presentation. Please take a few minutes to complete both surveys. If you're a non-member, please consider becoming a member of your respective state affiliate. This concludes our webinar. Thank you for your participation.